The Second Amendment is short in terms of number of words, but it may be more complicated than it sounds. The right to keep and bear arms shall not be infringed by the central government at a national level. However, the U.S. Constitution guarantees to the several states a republican form of government, and so they are sovereign. The states could then be more particular in their requirements if they choose. This would be a basis for licensing requirements, carry permits, and Brady Bill type purchasing restrictions. Arguably, the right to keep and bear arms is an individual right. If we want to change the language and intent of the Second Amendment, then it is an amendment issue, not a legislative one. Like prohibition and the right to franchise, 2/3 of Congress would need to agree to ratify the changes. If we were to argue that the right to keep and bear arms is a corporate right, we might intend to say that only the police and military should be allowed to keep and bear arms. Under that model, the meaning of the language would change to a well-regulated military being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This introduces two considerations. One, are civilians responsible for enforcing Third Amendment requirements against military barracking? And two, are civilians charged with preventing military coup? Clearly, this construction of the language argues for drastically more dramatic armament than hunting rifles, shotguns, and short arms. However, if Americans agree to this ill-advised state of affairs, the expression corporate right would give lawyers leave to argue for a group license of employees of security firms or private investigators and bail bonds businesses. While this too might appear agreeable, there would be no restriction or legal obstacle to a blanket gun permit for Google or GM employees or the Hells Angels LLC. Good or bad, the Second Amendment is the law of the land, and that really ought to be enough.